Ms. Lee, good morning.
Good morning. May it please the Court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The Commonwealth applied for and was granted further appellate review from the Appeals Court decision reversing the defendant's conviction for negligent operation. It is the Commonwealth's position that the Appeals Court not only applied the wrong standard of review, but shifted the burden of proof from the defendant to the Commonwealth. There was no objection to the refusal evidence in this case. The defendant
Just say,
claims...
I'm sorry, I just say that there was no objection.
There was no objection to the refusal evidence in this case. The objection came when the evidence of field sobriety tests began. There was...
Could you just...
Wasn't there a motion to suppress?
But it was a motion to suppress
Yes.
the reports, correct?
The motion to suppress is titled Motion to Suppress Field Sobriety Tests. And it begins, now comes the defendant and moves this honorable court to suppress any and all results of any field sobriety tests. And at the end it says, therefore, the test should be suppressed in their entirety. The refusal was the basis for the suppression of the field sobriety
What about
tests.
the reference during the hearing? I'm blanking, I'm bad with cases. On the case, you know, the case that talks about refusal evidence.
There's McGrail,
Yeah,
Rainier,
McGrail, thank you.
Grenier.
Yeah. Wasn't there, I haven't looked at the transcript, but that's what McGrail, that's the imported McGrail. Isn't that sufficient?
The Commonwealth would say no.
Okay.
And the reason is that this was a joint hearing on a motion to suppress and a bench trial. Prior to, and that was by agreement, prior to any...
Which should not have occurred.
It wasn't, I mean, it was kind of forced by agreement. I mean, there was a lot of efforts by the defendant to have it heard before, were there not?
There was a hearing date, and then it was continued. There was no objection to the continuance date by the defendant on that occurrence. That we have that transcript. And then on the date of the trial, that's scheduled for trial, defense attorney reminded the judge that we also have the outstanding motion to suppress, and the judge said, oh, yes, that's going to be heard in conjunction, and the defendant said, yes, Your Honor, there's no objection.
But whatever happened, how was the defendant harmed by this since he was was acquitted on the OUI charge?
Absolutely. The refusal evidence is relevant to one charge. The reason we don't permit refusal evidence at trial is because it is an implied admission of the defendant's testimonial thought processes.
It was used at sentencing, wasn't it?
No, the evidence of alcohol consumption was used at sentencing.
There was an admission. But the admission came in before the discussion about the test, at least from my reading. When she admitted to the officer that she had been drinking however many beers or beer, was before the discussion and the negotiation about the test. Isn't
Yes.
that right? So that would come in. I don't see, the defendant keeps arguing that that shouldn't have come in, but that was an admission separate, apart, before the discussion about the refusal and the tests and all that.
The only issue in this case is whether the refusal evidence was properly admitted. The defendant hasn't challenged her admission.
Do you need
So
a
you want
motion?
the admission anyway that she was drinking.
Do you need a motion to suppress refusal evidence, or is an objection sufficient at trial?
An objection would have been sufficient, but there was no objection. And the reason there was no objection is this refusal evidence was the basis of the motion. This is a one-page, one-paragraph motion. And the reason they wanted the field sobriety test is the issue that this Court decided in Blaze. And that is the refusal, does the refusal make the field sobriety tests involuntary? That is the motion to suppress. The defendant needed the evidence of the refusal in evidence at the motion to suppress, which is joined with the bench trial, in order to make the argument, my field sobriety tests are not admissible. And the judge correctly decided that issue, as was done in Blaze by this Court, that no, that doesn't make the tests involuntary. That's the issue the defendant was presenting. You see the defendant's argument when they're arguing the motion to suppress. Her argument is no means no, that should have ended there. No, and he continually, the defense attorney for the defendant says, no means no, continually throughout, meaning this is a non-consensual field sobriety test.
Yeah, but
If we look at then at the substantial risk standard, I agree with you. That's precisely, as I read the transcript, what was going on here. I take it that we should presume that the judge was aware that the refusal evidence itself would not be admissible, right?
Yes,
and
we
therefore, presume he would not have used it.
Under Marungu, Montanez, Ortiz, we presume that trial judges know the law and correctly apply it.
And indeed he found her not guilty.
And he found her not guilty on the OUI. And so what we have here is the appeals court, one, finding that the objection was preserved. It was not. The refusal evidence comes in at least 3 times prior to the objection, and the objection comes in at the field sobriety test. He says, I have to object. This is that aspect of the motion. The motion is not requesting suppression of the refusal evidence. Defendant even says in her brief before this court that in the motion to suppress, defendant painted with a broad brush. But
Lee, can I just ask you this, on that the judge knew? In her reply brief, she says the judge then considered and rejected defendant's argument that the refusal evidence should be excluded. I take it your point is, if we look at the transcript, it shouldn't have been excluded for the motion to suppress, correct?
absolutely, it couldn't be. Otherwise, they couldn't hear the motion to suppress. The refusal evidence had to come in for the motion to suppress.
So isn't one of the problems here that by mushing them, you can have the 2 hearings back to back?
Right. In Kearns, this court noted that in bench trials, you often don't have the same kind of precision of rulings. And look at this case. The defendant knew prior to going into any hearing that the judge would hear the refusal evidence and then immediately hear the issue of her guilt or innocence. And it's not until on appeal that she determines that the judge must have misused this refusal evidence.
And you're saying if we look at the transcript carefully, there will be nothing that suggests that the judge is using the refusal evidence for conviction purposes or sentencing purposes?
No. He uses the intoxication to determine what her conditions should be at, on probation. He never references refusal. It's not argued by the Commonwealth. It's not in his findings. It's not mentioned in his sentencing. What he says is, there's evidence of drinking. I don't find enough to find that you are impaired, so you're not guilty on the OUI. But there's evidence you were drinking that night. There was evidence she was drinking that night. She admitted she was drinking. She couldn't say her ABCs. She wasn't speaking in the manner she normally could. I understand she has a broken jaw, but the police officer had talked to her before, and she wasn't speaking in her normal tone. He smelled alcohol. She had glassy eyes. She went through the red light. The judge was well within his fact-finding abilities to say that she was drinking without any reference to the refusal.
Just to make quite sure, okay, one, your position is that the appeals court used the incorrect standard.
Yes.
And two, I'm looking at its opening paragraph, it has sort of 3 sentences. Prior to trial, filed a motion to suppress. That motion was denied because we conclude the defendant was prejudiced by the improper admission of evidence of her initial refusal. Any fair reading of that means the motion was denied, and then at whatever the trial was, that evidence came in, and you're saying a careful read will tell you, no, the refusal was all in connection with the motion to suppress.
I would suggest that the record does not clearly state what the judge was saying as to the refusal evidence, and the reason for that falls squarely on the defendant, because they never raised that issue. And so just as in Kearns, as Kearns court noted, you won't have that precision. That's why under Rule 13, the defendant is required to raise in the motion to suppress all grounds with particularity. And you won't see that in their motion to suppress.
So when did the motion to suppress hearing end and the trial go into a state of abeyance for purposes of deciding the motion to suppress?
It was done joined together.
Well, but when I asked you if the refusal evidence could be the subject of an objection, you said, yes, it can be. You don't need a motion to suppress. But at the same time, it was essential to triggering the motion to suppress. So for purposes of motion to suppress, you need, or the defendant needed, the refusal evidence. And she could have objected at trial to keep the refusal evidence out. So when did the motion to suppress start and the trial go into abeyance?
Well, I would say the trial was not in abeyance at any point because it's a joint proceeding that was agreed to. If the defendant wanted to preserve the issue, she had to file a motion to suppress the refusal evidence or object to the refusal evidence at trial. So what she could have done is put it in her motion to suppress, which she did not do, or she could have objected when the refusal evidence comes in and asked for a limitation on it. Judge, this is only for the purposes of the motion to suppress. Or even when the judge made the findings, I'm going to let the evidence in, go ahead, defendant could have stood up then and said, Judge, just so the record is clear, that doesn't include the refusal evidence, right, because that's inadmissible under McGrail and Grenier, cases that were cited for the voluntariness issue during the argument on the motion to suppress.
I may be missing something. I think you said the defendant did not specify with any degree of accuracy what the ground for the motion to suppress was.
Particularity.
Particularity. I'm reading the motion. They say two things. First, it was not voluntary, it was coerced. And second, it violates the right to incriminate yourself. Now, what's wrong with those two grounds?
I would suggest that it doesn't ask for suppression of the refusal. It asks for suppression of the field sobriety tests.
Isn't, I mean,
Oh, heck, they're
Can't
all
you use
tied
a little-
together.
mushed together.
Yeah, you
The
can't.
refusal evidence precedes the field sobriety
but,
tests.
I mean, a little reasonable thinking about this would have them thought of as part of the same package, wouldn't it?
Yes.
I would suggest that in these circumstances, it just isn't so. That's not what they were arguing. They were arguing the voluntariness of the test. In the event that this court finds that it was preserved, which the Commonwealth does not concede, the Commonwealth maintains that this motion does not meet Rule 13. It does not meet O'Brien, where Miranda was preserved and voluntariness was not. It does not meet Bradshaw, where constitutional issues were not preserved. I would suggest, even if you find that the standard of review is harmless beyond a reasonable doubt, the defendant was acquitted on the charge of operating under the influence.
Yeah, so we can skip over all this other stuff
I would,
and just say, assuming this and that and the other thing, get right down to the acquittal, and therefore find it could not have affected the negligent operation conviction.
it could not have.
End of situation.
And also, in these
Rescript opinion.
in these circumstances, the appeals court declined to follow this court's precedent, stating that we presume that trial judges know the law and apply it correctly in the absence of evidence to the
Well,
contrary.
the judge got the motion to suppress wrong.
No, he got it right, because he followed what this court said in Blaze, that the field sobriety test could then be offered. And when he said, I'm letting the evidence in, the evidence of the field sobriety test was offered. And there was
Also
no,
the evidence of the refusal.
the refusal preceded his ruling. He said, I'm letting the evidence in, and then the evidence of the failed alphabet test was offered.
This may not be relevant. Was the light red or was it changing to red?
Changing, I think.
Oh,
The appeals court
that
says...
she went through the red light, I
The appeals court
believe.
says changing. So if we look at, on the evidence before him, and looking to the negligent driving, the appeals court says was less than overwhelming. So what is that evidence once we take out? Let's assume that it's preserved, Ms. Lee. So what's the evidence of negligent driving?
The evidence of negligent driving, if it said, is, the truck continued moving even though the light at the intersection was red. That's what the officer testified to.
So where
It's at
does that-
transcript
so
2,
where-
page 25.
Where does the appeals court get it was changing to red? And then you've got her swaying close to the solid yellow line but not crossing it. What other evidence was it?
That's about it.
On page 25, I came up behind it was, we approached the intersection of Union Street and West Water Street. It's called Union Square. There's a set of lights there, and I noticed the vehicle go through a red light. You said you noted the vehicle go through a red light. I did. So I activated my
check.
lights.
I don't know whether something came out on cross-examination or maybe...
Perhaps it came out on cross-examination,
so
but the
from
officer
your point of
testified
view-
that it went through a red light.
Beyond a reasonable doubt. So what's the evidence?
I'm sorry?
Beyond a reasonable doubt, let's assume that he can't take into account
The defendant doesn't challenge the evidence of negligent operation here, or that there was insufficient evidence, and we shouldn't be second-guessing the trial judge as a fact finder. He heard the evidence, he listened to it, there was evidence that she went through a red light under Carlson, and he could credit that. And under Carlson, that's negligent operation, and so that's sufficient evidence. And it's not the appellate court's function to then become the second fact finder as well. It is the appellate court's function to make sure the law was applied correctly. And
so
this...
essentially, as I read the appeals court, what they are saying is, in these circumstances, whatever these circumstances, this case, it's a as you said to Justice Spina, the trial began at the beginning and the motion to suppress never stopped, and so you've got these circumstances. The record indicates that the judge may have considered improperly admitted evidence, and you're saying simply if the evidence is uncontested that she drove through a red light, that in and of itself is sufficient, so you can slip out everything else.
Refusal evidence isn't relevant to the negligent driving, and there's no indication that the judge considered it or was swayed by it. Barrett is completely an opposite because there's a not guilty finding here on the OUI. It's certainly no substantial risk of a miscarriage of justice, which we maintain is the correct standard, and of course is harmless beyond a reasonable doubt because there's an acquittal, and that is the Commonwealth's position. I would ask you to affirm the conviction for negligent operation.
Thank you, Ms. Lee.
Thank you.
Ms. Salon?
Good morning.
Good
May
morning.
it please the court. My name is Karen Salon. I represent the defendant, Charlene Healy.
How was the defendant harmed, even if we assume that the appeals court standard is correct, that it was harmless beyond a reasonable doubt? How was the defendant harmed by the refusal evidence if she was acquitted of the OUI charge?
Because at the end of the trial, when the judge was discussing his findings, he said, I don't think I have enough on the OUI, but I'm going to find you guilty on the negligent driving because I think you were drinking, I think you have a drinking problem, and here's what I'm going to do to help you address
Okay, but
it.
she said to the officer she was drinking before they got into the discussion about taking the test, so that's admissible evidence regardless of how we rule on the refusal evidence.
Certainly, Your Honor, and the
So,
defendant...
so he said, I think you were drinking. She said she was drinking. It came in a trial, so what did he do wrong?
Well, this was, the stop, I believe, occurred about 10 o'clock at night, and she said to the officer, I was drinking earlier in the day. There was no further evidence on when she was drinking, how much she was drinking. What really, when it really came to bear was when they started this discussion of the sobriety test.
How did the discussion of the sobriety test affect the fact that she was drinking earlier in the day?
Well, when he asked her to do the field sobriety test, he said, I want you to recite. He asked if she was willing to do some tests. She said no. And she said it so emphatically that he was taken aback. And up until this point, there is some evidence that there was no odor of alcohol. He asked if she had been drinking. She said, I was drinking earlier in the day. And when he asked her to do the test, she said no. And he said, wait. Just all I'm going to do is ask you to do your ABCs. And she said, AB, and he stopped her, and she got very upset. And she said, I was just going to the store. And she was, it's hard to say based on the transcript, but it appears that she was a bit hysterical. And he had to calm her down and say, no. I was just going to ask you to do your ABCs. I haven't asked you to start. And so here she is getting hysterical and trying to get out of it after she had said no. This was all, and the defendant argued this at the suppression hearing, all part and parcel of what the trial attorney called a negotiation-type refusal. Under the Grenier case, the appeals court case that her attorney cited to the trial judge, this is all a refusal evidence, and it's all out. And that's
Right,
what he's arguing.
but she's still, before all this refusal evidence comes in, before that time, she said, I've been drinking. And the judge said, there was evidence that takes into account the fact that she was drinking.
He did take into account the fact that she was drinking, and all of the evidence of alcohol consumption is relevant to that finding. And as this court stated in Barrett, we can only speculate as to what factors he truly considered in finding. I think the drinking was
I
enough
take
of
it
a
your position is she says I'm drinking earlier in the day.
certainly.
There's no evidence, you would say, that she is inebriated at the time that she's drinking.
Absolutely, there's nothing.
And he acquitted her of the OUI.
He
Okay.
acquitted her of the OUI, yes.
But wasn't there evidence that the police officer smelled a strong odor of alcohol? There was evidence that her speech was thickly slurred? There was considerable evidence of intoxication.
All of that evidence, for every point there was a counterpoint that came out at trial, and I'm
But
assuming
the
he could
judge
have
properly
credited-
could have considered a properly admitted evidence of intoxication.
He could have considered all of it, and he should have considered everything that was properly admitted, and he should have considered everything that he believed was properly admitted, which included the refusal evidence. So he could and should have considered all the evidence before him, and that included, in this case, refusal evidence that should not have been admitted.
And your point, or your argument, is that saying the ABCs is inextricably intertwined with the refusal?
Saying the ABCs, I'm not arguing to this court that the actual recital of the ABCs should have been excluded, because that is clear under Blaze and Hinckley, that she had no
That's
right to refuse.
So doesn't that just add to the evidence that one could infer she had been drinking at the time?
Certainly, but that's also taken together with evidence that should not have been admitted in this case, which is this discussion about the ABCs, which transmits her belief, I believe I'm too intoxicated to do it correctly. So it's, although it's difficult to do because it was all one long discussion that culminated in her getting it wrong, that's what happened in Ranieri, in which the appeals court said, no, we're sending it back to the trial court because this discussion that preceded the ABCs was inadmissible.
Did trial counsel specifically argue to the judge that the defendant's refusal, her no, should not come in?
He argued, what happened was, it came, at the beginning of the trial, on page 19 of the transcript, he reminded the judge that the motion to suppress was still pending. And the judge said, we are going to incorporate that and make it part of the trial. So from that point on, the judge was hearing both the suppression hearing and the trial. And so the evidence, the no came in, and then there was one more question. Well, what happened after that? She started, and I told her to stop. And then the defendant's attorney stood up and said, this is the aspect of the motion that needs to be addressed. He reminded the judge that this was also a suppression hearing. And then they proceeded to argue. At that point, he argued that under McGrail and Grenier, it's out. And
It's out because it was not voluntary?
well, there's no other holding in Grenier. Grenier was a one-issue case, and Grenier was not a voluntariness case. McGrail has
But the motion to suppress was.
the motion to
The
suppress.
focus of the motion to suppress was voluntariness. It was not the refusal evidence.
He did state voluntariness, but he also did state in the motion to suppress that he asked that the test be excluded in their entirety, and I think that can fairly be read to include the refusal and the negotiation, everything that followed, and he properly said in the motion to suppress that the test violated her right under Article 12 not to furnish evidence against herself. Although he didn't state with great clarity that the refusal evidence should be excluded, I think it can fairly be read into the motion. And then you couple that with the argument at the suppression hearing that Grenier applies. He argued that the refusal evidence should be excluded as well, and the motion was denied. And under the cases that the Commonwealth cites, Rivera, O'Brien, the real problem with cases that in which the waiver doctrine is held to apply is that the facts aren't sufficiently developed at the suppression hearing, and then there's nothing on which the issue can fairly be decided on appeal. That didn't happen here. The facts were very simple, and they were all laid out at this combination suppression hearing and trial. She refused, there was a discussion, and then she did the test. Well, the refusal in this discussion should have been excluded from evidence. And the judge here specifically said, the motion's denied, I'm going to hear the evidence. At that point, you can no longer assume that the judge is properly applying the law and properly considering only admissible evidence, because he has specifically denied the
That may
suppression
be
motion.
correct, but we can look at the evidence and determine whether it was not prejudicial beyond a reasonable doubt, because there was sufficient evidence to which there was no objection to support that conviction. Correct?
Under the statute, there was sufficient evidence to support the conviction. But again, here, the judge said
Can I just ask you
explicitly-
about that? He finds her not guilty of operating under the influence and not responsible for failure to stop or yield in violation of 89 Section 9. Does that mean he found that she didn't go through
Well, the evidence on
light changing to red or red light?
Well, on cross-examination, the officer did say the light turned yellow when she was 1 or 2 car lengths from the intersection. That's on page 53 of the transcript. The judge may very well have found that she did not run a red light. Again, we don't know. He didn't say the light was red or the light was yellow. We don't know.
But he found her not guilty of that, right?
He found her not guilty.
So presumably, if we're looking at prejudicial beyond a reasonable doubt, we have to take out that evidence, too.
Sure.
Well, what's left then?
What's left
Why
is
do we
that
have to take out the going through the red light? The officer testified she was going through the red light. Why do we have to take that out?
he testified
The
on
judge found her not guilty.
the
Of
judge found her not
OUI,
responsible
not of
for.
operating to
Well, it
endanger.
says here, and not responsible for failure to stop or yield in violation of 89.9.
So
I'm
what's
reading the appeals court opinion.
There can be inconsistent verdicts.
So what's left?
She's
I mean,
swayed, after
I
the
take it
active-
she's found not guilty of driving under, not guilty of running a red light,
Right. And
correct?
after, yes, and
So
after he
presumably he believed, I mean, I don't know, because the judge isn't explicit, but presumably he believed the officer's testimony that the light was red, was yellow turning to red, and it's on that that's why I asked Ms. Lee.
the
So we
negligent
have to
operation.
take, so we take that out.
Right, the negligent operations statute is so wide open that really the facts here that might lend itself to it is she went through a light turning yellow when she ought to have stopped if she was exercising better judgment, and she swayed close to the yellow line but did not cross it after he activated his light bar. I can say I do that every day when I'm yelling at my kids in the back seat, but I don't believe I'd be sentenced to 2 years suspended sentence and placed on probation for it. I think I would probably get a ticket or a warning. Here
Has
he
she
said-
completed her probation?
Excuse me?
Has she completed her probation now? Just out of
Yes, I
interest?
believe it was completed this past summer. And here he said, I'm not going to quaff it because I think you need to address your alcohol problems. And that's the problem that the defendant has with the consideration of the refusal evidence here.
But did
That's
she
so
have a
bizarre,
prior?
because the fact that she said no, in light of the fact that she then took the test, which was admissible and didn't pass it, and the fact that she admitted drinking, I mean, how does no increase the judge's sense that she had been drinking? I don't understand that.
Well, the sense is when the officer asked her to do it, when she says no, what she really means is, oh my God, I can't pass this test. How can I get out of this?
And then she took the test and didn't pass it.
Then she took the test and didn't
Okay,
pass.
So that's in evidence.
That's in evidence. The refusal is in evidence, but it ought not to be. And we can't plumb the depths of the judge's mind and figure out exactly what drove him to say.
Did she have a
Okay.
past record?
She did, yes.
And that was for?
There were some assault charges. I don't recall whether there were OUIs back there, but he said.
This reference to personal animus, alleged personal animus on the part of the police officer, that's out?
That's, there was no evidence. The only evidence at trial really was that he knew her from past dealings, and the evidence did not go further than that.
But you say at the argument on the motion to suppress, defense counsel specifically said that the refusal evidence should also be suppressed.
He did not use those words. He argued that under, I believe his words were, under Grenier, it's out. And he pressed that his citation.
Under Grenier, what's out?
That's an excellent question. The judge started off on, I believe, page 38, right when the defense counsel spoke up and said this is the aspect of the motion. The judge seemed to be under the misimpression that she did have a right to refuse the test, and the judge was looking at it as no means no, and is the test out? And I can't say whether her counsel really believed that to be the case or not, but he certainly went along with it, said, boy, this judge thinks that I can get the whole test out, so I'm going to go for that. But his argument really was focused on McGrail and Grenier, which are, McGrail is the seminal sobriety refusal case, and Grenier came after and focuses only on the negotiation aspect of the refusal, and says that there was this whole, in Grenier, the defendant offered some sort of a lame excuse that, well, police officer is trained to stand on one leg, and geez, if I do it and I fail, you're going to arrest me, and if I refuse to do it, you're going to arrest me anyway, so take me. That was all held to be a refusal that was inadmissible under McGrail. The Commonwealth also argues that the particularity requirement is fatal to the defendant here, and that really, the particularity requirement gets you a hearing if you satisfy that, and the goal of that requirement is to put the court and the other party on notice as to the facts that support your motion and what your theories are. Once the defendant argued at the hearing here that under Grenier the refusal was also out, or telegraphed that under Grenier the refusal was also out, the waiver doctrine no longer applies. The issue is preserved. The panel of
Just one final question. You're not arguing that the motion to suppress the field sobriety test should have been allowed on this appeal. You're not arguing
I'm not arguing that her actual recitation of the alphabet should have been suppressed. I don't think I could argue that under Blaze. But I would point out that Blaze has now been decided for 10 years, and in that case, this court said, well, we really leave it to the legislature to come up with some mechanism to coerce people to do these tests, similar to, the breathalyzer test, and nothing's happened in the legislature, leaving motorists and police to figure it out on the road. And this is the problem. I wouldn't say that this would be the test case, but out in the field, the police don't have any guidance from the legislature, and there hasn't been any opportunity to test in the courts how far they can go to get people to say their ABCs. All they know is they can't hold a gun to a person's head, and the legislature isn't going to take the person's license away or anything of that sort if they refuse to do it. So there's sort of an open question there as to how far the officer can go. Here, I wouldn't argue that he went too far by saying, hey, calm down. I'm just going to ask you to do the alphabet.
Thank you, Ms. Salon.
Thank you very much.